Good morning, everyone. Welcome to Lindner and Marsak's annual firm seminar, labor session. This is the last of 3 sessions that we've held over the last 3 weeks. My name is Chris Hansen. I'm one of the shareholders on the labor and employment team here at Lindner and Marsak. The primary focus of my practice is labor relations, labor negotiations. I also do some litigated work. I know a number of you who are on the session today. So welcome to you, and welcome to all of you who I do not know. David Keating, who is another one of our labor attorneys here, was going to join me, but David is in Cleveland, Ohio, involved in a rather intense labor negotiations right now. And so David is unfortunately not able to join us. We do have Jonathan Swain and Gary Marsak, who are also labor lawyers with the firm. And neither of those gentlemen are available either. So unfortunately, or maybe fortunately, you are stuck with just me today. I'll try to make it as entertaining as labor law updates can be at 8 a.m. on a Wednesday morning. It's been a pretty challenging year, and so we're doing this virtually. It's our hope next year that we'll be back to our annual in-person sessions, but I'm very thankful that all of you have showed up today for the virtual session. As we get started, please feel free to use the Q&A button at the bottom of your screen to ask any questions that you may have. I'll try to address them in a timely fashion as we go along. There are no dumb questions, so if anything pops into your head, try to keep it to labor law type issues. Otherwise, there's a fairly good chance I won't know the answer. We have applied for CLE and SHRM credits for this seminar, so we'll let you know when they have been approved. And also, at the end of this meeting today, we will be drawing a name for a $100 Amazon gift card. So please stay tuned to see if you are the lucky winner. You should have received a copy of today's presentation via email yesterday. If you did not receive it, you can email us at info@lindner-marsak.com and we will send you a copy. The email address is also in the chat. And with that, let's get started. As you know, labor and employment law are real, as far as the law is concerned, are very political animals. And with each changing administration, administration, whether on the state or federal level, often what follows are significant changes to either the law, how the law is interpreted, or those who are interpreting it. And that's no different with the change to the Biden administration from the Trump administration. We're coming off of 4 years in which the National Labor Relations Board and the Department of Labor have been led by conservatives and Republicans, and an era where most of the decisions have been made favoring employers. Changes to policies at the National Labor Relations Board have been favorable to employers. With the change to the Biden administration and the appointment of Democrats to lead these agencies, it is likely, and it has already occurred, that changes that we'll see now will be more employee-friendly and more union-friendly. Some of the changes that have already been made, the Department of Labor chair is former Boston Mayor Marty Walsh, You'll note that Mr. Walsh is a former union employee himself and the former president of Laborers Local 223 in Massachusetts. So obviously he has a long history of having been both a union worker and a union leader. So his bent is obvious to most. One of the things that he was a big proponent of as mayor of Boston was paid leave for men, women, and same-sex couples. And he enacted an ordinance originally that was 6 weeks of paid leave for city workers in Boston, and ultimately that was increased to 12 weeks. There has been some push for paid leave, particularly FMLA leave, for the birth of a child, among others, but that has been a pretty significant push. That actually started during the Trump administration. My anticipation is that it will continue in the current administration. As far as the National Labor Relations Board is concerned, the acting general counsel presently is Peter Soong Orr. President Biden fired the general counsel who was in that position when he took office, Peter Robb. That was a somewhat surprising move in that it was not precedented. Ordinarily, those individuals in the general counsel role serve for a term, and when that term runs out, the general counsel is replaced by someone who is more politically aligned with the president at the time. I think what this did was really signaled to everybody immediately, because on Inauguration Day, President Biden asked Peter Robb to resign. Mr. Robb refused, and Mr. Biden then fired him. That obviously signaled that there was going to be a changing in the guard and a change in exactly the approach that the NLRB was likely going to take with respect to labor-related issues. Acting General Counsel Orr then immediately rescinded, or as close to immediately as possible, rescinded multiple Attorney General memos that were issued by Mr. Robb. Those memos often provide a guideline for employers and the board itself as to how certain issues are going to be interpreted. They provide significant guidance as to what sort of policies will be acceptable under labor relations law and before the board. A couple of those that were rescinded were a handbook policy memo, and I'll touch on the handbook policy and the board's position on handbook policies as it had been articulated, and what we can probably see change with that in the coming months, if not throughout the course of the Biden administration. And another memo that was rescinded was the neutrality agreement memo. And neutrality agreements are put in place generally when a union is attempting to certify at a particular employer. And the idea being that the employer is to remain neutral. The employer is not to provide anything other than ministerial assistance to the union in its efforts to obtain certification at a particular employer. That generally means that they would simply allow the employees to communicate with union members, perhaps during breaks, things of that nature, but not provide detailed information to them. And in situations where such neutrality agreements aren't in place, employers can provide contact information for all the employees in the bargaining unit to the union. Under General Counsel Robb and the Trump administration, neutrality agreements were not supported. Now under Acting General Counsel Orr and the current National Labor Relations Board, employers are allowed to assist unions more significantly than they were in the past. And the thought being there that that assistance may ultimately lead to an easier course for unions to certify at employers. Another thing that Acting General Counsel Orr did was issue a memorandum on March 31 of 2021, stating that his office will return to, quote, vigorous enforcement, unquote, of employee Section 7 rights. Now, Section 7 rights, in their most basic terms, are those rights that allow employees to join a union or to not join a union. But probably most significantly, they really are the rights that give employees the ability to complain about their job, complain about their supervisors. It's referred to as protected concerted activity, and those complaints generally can relate to work rules, pay, things like that have to do with the terms and conditions of one's employment. And those complaints or those statements or those efforts to combine with fellow workers or others to make change or affect change are protected under Section 7, with limitations, obviously, given the manner in which that in which those concerted rights are expressed. Under Acting General Counsel Orr, the idea behind vigorous enforcement is the thought that there was less than vigorous enforcement of these rights during the Trump administration, and with the National Labor Relations Board being a majority Republican appointees. Of note, you had to have been living under a rock probably to not notice that there had been considerable protesting that had been going on over the course of the last year, despite the pandemic, following primarily the death of George Floyd in the Twin Cities. Therefore, as part of this vigorous enforcement of Section 7 rights, Acting General Counsel Orr had stated that these Section 7 rights, which traditionally would not cover political and social justice advocacy necessarily, he stated that employees' political and social justice advocacy, when the subject matter has a direct nexus to employees' interests as employees, would be protected. Now, as most of us know, in a private sector, an employer and employees specifically do not have First Amendment rights as it relates to their employment. And this creates a bit of a conundrum for employers, because political and social justice advocacy are the hallmark of First Amendment rights. And this gives employees the ability to speak on issues such as living on a minimum wage. And there's some examples listed here, such as media interviews regarding that subject, protests over workplace immigration raids by the government, joining such protests, even an employee's solo strike to join a demonstration advocating for $15 per hour minimum wage. The interesting thing about that is ordinarily employees are not allowed, in most collective bargaining agreements, forbid striking during the term of a contract or engaging in intentional slowdowns in protest. these self-help type remedies aren't lawful, and as a result can lead to discipline and or termination, up to termination. This makes such solo strikes likely allowed, so that if an employee wants to join a demonstration with, say, McDonald's workers, because they've walked out a few times over the course of the last year to advocate for $15 per hour minimum wage. If one of your employees does that, you have to be very careful in how you treat that employee. And it should note, even though I think most of you probably know it, that the National Labor Relations Act, while generally thought of as a law that pertains to unions and those employers who have unionized workforces, it actually applies to non-unionized workforces alike. So you do have to be cautious when you take action against employees for joining protests, perhaps taking a day off. I know last year the SEIU union formed a coalition among other with other unions, and to protest living wage, to protest discrimination in the workplace, largely supportive of the Black Lives Matter movement. And there were a number of employers who were affected by that. And you have to stay on the lookout for those type of protests, because they seem to come from somewhat of a grassroots type place, but most of them are really driven by larger unions, the SEIU being one of the largest unions in the country. Concerning the NLRB members themselves, President Biden named Lauren McFerrin, a Democrat employee, the chairperson of the National Labor Relations Board, shortly after he took office. He nominated Gwen Wilcox, an employee rights attorney, in May of 2021. Ms. Wilcox has yet to be confirmed, but the thought is that she will be. Right now, there remains a Republican majority on the board. However, right now it's a 2-2 split until Ms. Wilcox it will be confirmed. But then Mr. Emanuel, as you see, his term will end August 27th, 2021, and President Biden will be able to appoint a replacement. And so it would appear that a 3-2 Democrat majority will prevail. What that largely means is that a number of the decisions that have come down during the Trump administration, if challenged and taken all the way to the board level under the newly constructed NLRB, will likely see a different fate. It's not a certainty, but it is more likely than not that a number of those decisions will get overturned, and I will touch on a few of those in a moment. Another thing that President Biden did was he created a task force that's led by Vice President Harris, and it's entirely designed to drive union membership. The talking points on that from the administration are that unions benefit workers, and that it is important for workers to have a voice, and the best way for them to do that is to join a union. The cynical view on that is that unions, by and large, support Democratic politicians, and the more union workers there are, the more potentially, anyway, Democratic voters there will be. And you can see from the slide that union membership continues to decline. The decline is not quite as precipitous as it was starting from maybe the late 70s, early 80s until 2000 and the early 2000s, but union membership did decline 2.2% in 2020, with at least 13 of the largest unions in the US losing members last year. Unite Here, which primarily represents workers in the hospitality industry, lost 56% of its members. Now, a lot of that was driven by the fact that hospitality took the greatest hit during the pandemic from an employment perspective. So we'll see to what extent their membership bounces back as states and municipalities start to open up more and more. Anecdotally, I've noticed, and I think many of you probably have too, that the one area where, or the one sector where businesses are having the hardest time getting employees to come back to work is the restaurant and hospitality industry. Some of that is driven by the fact that here in Wisconsin, there still is additional unemployment money available. But other of it is driven by the fact that a lot of these employees have found other jobs and perhaps don't want to go back to what they think is maybe a less stable work environment in the hospitality industry. Overall, the rate of union membership is 10.8% of employees. In the private sector alone, that's 6.7%. Public sector, 34.8%. Traditionally, public sectors over the course of the last 30 years, the public sector has seen better union representation, but an indication of just how far union membership, the rate of union membership has dropped. If you look at 1983, 20.1% of workers were unionized, a total of 17.7 million workers. In 2020, as I indicated, 10.8% is the rate, and that's 14.4 million workers. You'll note that the percentages don't necessarily equate to the numbers. That's just because the workforce has expanded considerably from 1983 to 2020, but the percentage has been a very significant decrease in unionization. Continuing with changes already made, and I had signaled that there were some National Labor Relations Board decisions that were significant. One of them is not actually a change. Many thought that what is known as the contract bar doctrine was headed towards overturn by the Trump board, and it did not change. Contract bar is, in its basic form, a doctrine that prevents a union from decertifying during the first 3 years of a labor contract. It is one of the reasons why many unions push for contracts that are no longer than 3 years. If a contract extends beyond 3 years, any point during the period of time that's longer than 3 years, a union would be able to decertify. With a 3-year contract, there's just a small window at the end of that contract during which a decertification can occur. The thought is that the board was going to issue a decision that would overturn the contract bar standard, and unfortunately for employers, particularly those who would like to have unions at their facilities decertify, it did not change in that Mount Ayr Farms decision issued April of this year. Another issue that had been of significant consideration, particularly during the Obama administration, was confidentiality of investigations. And under the Obama administration, an effort was made to prohibit confidentiality requirements in investigations because they felt that that infringed upon Section 7 rights, which I discussed a moment ago. And ultimately, what the board did recently was confirm that confidentiality rules are lawful so long as they only apply during the duration of an open investigation. In this case, an administrative law judge originally found that the employer had violated the National Labor Relations Act because it had not specifically limited the confidentiality rule. The confidentiality rule that the employer had in place required that employees maintain confidentiality with respect to workplace investigations. It did not necessarily indicate that only while those investigations are open, but the National Labor Relations Board reversed the administrative law judge, finding that employees would reasonably understand the rule would end when the investigation was complete. One of the things to note about National Labor Relations Board decisions with the current board and the board as it was constituted during the Trump administration is that they tended to give employees a little bit more credit, or in certain cases, quite a lot more credit, as far as their ability to reasonably understand what a rule meant. And you'll see if you follow these decisions, once the board is finally confirmed as a 3-2 Democrat majority come the end of August or early September, that there's less of that from the board, that rules need to explicitly identify things like the fact that confidentiality rule would apply only while an investigation is ongoing, because once the board is reconstituted, it's going to be less likely to find that a rule that they might consider vague would be reasonably understood to mean anything other than what the words in the rule actually state. So it's one thing to keep in mind as we draft rules is it's best to be specific as possible. It's great when it's great for employers when the board is more employer friendly, such that rules would be construed in a manner favorable to the employer. But because the board tends to change, and the change can be fairly drastic when there's a new administration from a different party, it's almost a best practice to make sure that your rules will be enforceable if and when the administration and the board construct changes. Another significant decision issued in April related to blogging, blocking, and solicitation policies in employment manuals. David Sachs Productions, the case decided April 5th, 2021. That case involved employer rules regarding blogging, employer rule regarding a signature block in an email, and an employer rule regarding solicitation. The rules were challenged as rules that infringed upon employees' Section 7 rights, in that they were overbroad. The challenge was that they were overbroad. The employer's blogging rule banned blogging that might harm or tarnish the image, reputation, and/or goodwill of the employer. Now, as you probably know, in protected Section 7 rights, employees can say some pretty nasty things about employers, and those things potentially could harm or tarnish the image or reputation of the employer. The idea behind them is, so long as they're not defamatory, meaning that they're false, knowingly false, or something an employee should know is false, they're entitled to say those things, generally speaking. The challenge here is that because the rule didn't really specify the type of speech that was barred by using the term harm or tarnish, that it was overbroad. The rule also banned discriminatory, disparaging, defamatory, and harassing comments. Those things obviously are all out of bounds and are not protected by Section 7 rights, but it didn't state that the harming or tarnishing of the image of the employer was limited to those type of comments. And the board, using the current standard for workplace rules, which I'll touch on, is stated that while the rule may adversely affect protected activity, said that the protection of the company reputation and goodwill, or ultimately the purpose of the rule, outweighed any adverse impact that the rule had. In addition, the board held that the employer was allowed to ban customized signature blocks in company emails. The region argued that this was simply an analogy to wearing union insignia. However, the board stated that it led to the potential impression that including, say, a union insignia on a union member's signature block might mean that the company was endorsing the union, or that the statements made in a particular email might be endorsed by both the employer and the union. And it was just a signal by the board that in certain contexts, such as letterhead or signature blocks, companies are allowed to create uniformity there, and that in creating the uniformity, it wasn't necessarily intended to discriminate against union activity. It was really an effort by the company to make uniform the signature blocks for every employee. It wasn't cherry picking which customized signature blocks were allowed. It was simply banning customized signature blocks in their entirety. And the final element of this case is that the board upheld the employer's ban on solicitation and distribution by outside people within or on the company's property. And again, because it did not discriminate against union activity, but was an overall ban on that type of solicitation and distribution, that it was lawful. The argument against it was that in general, the outside people or organizations who ran afoul of this rule were unions. It wasn't third-party contractors or people like that. But because the rule applied to salespersons and individuals of that sort, in addition to unions, it was held to be lawful. Now, some changes on the horizon that we can probably expect to see. Under the previous general counsel for the board, Mr. Robb, he sought to clarify that an employer may lawfully terminate an employee who refers to his or her supervisor on Facebook in outrageously obscene language. There had been a number of decisions over the course of the last few years concerning the use of social media, and the board had continually tightened what employees could say on social media, such that they could complain, obviously, and engage in Section 7 activity, but the board did rein in some of the language that was used in these posts, and did clarify that the posts had to actually seek to engage others as opposed to just standalones. And the argument against that, of course, is anybody who likes it is now, at least in the Facebook context, anybody who liked it would make a statement made by anyone on Facebook concerted activity. In addition, Mr. Robb had sought to restrict the use of employers' email systems to work only, and he had urged the board to prohibit off-duty employees from picketing on an employer's property directly in front of its doorways. Acting General Counsel Orr and the nominated General Counsel, Ms. Abruzzo, they will likely seek to reverse each one of these positions and provide more protections for employees. Ms. Abruzzo had a full hearing. It's anticipated that she will likely be approved by the Senate in relatively short order. She does have a long history of employee advocacy, and has been affiliated with the NLRB in various council roles over the course of the last 20 years. I referenced a couple of times handbook rules, and current board law was developed in the Boeing Company case in 2017. And that established a new test that placed rules in 3 categories. The first category were rules that are deemed lawful because they don't, on their face, interfere with National Labor Relations Act rights, particularly Section 7 rights, or that the potential adverse impact on the National Labor Relations rights is far outweighed by justifications for the rule. These are the type of rules where really looking at them objectively, there is no question that the rule would be lawful. To the extent that it limits any speech, it's minimal. And as a result, that doesn't take a very significant overview or review by the board to determine that the rule is lawful. Examples were no camera requirements, where there was limited restriction on an employee's ability to engage in Section 7 activity because there is confidential proprietary data that can be gleaned from an employee using a camera in the workplace. In addition, now, more than ever in the history of our country, by simply having a telephone in your pocket, everybody has a camera and a video camera on them at pretty much all times. I'm thankful that there were no such things when I was in college, because I probably wouldn't be sitting here before you today. In addition, rules requiring basic civility standards, to the point that I made about the Facebook posting. The idea is that if rules forbid, vulgar commentary, commentary that is sexual in nature, those rules are generally going to be upheld. There is a bit of a fine line that will probably reveal itself once again when it comes to complaining about wages or work rules on social media. It's likely that the words that employees will be able to use might strain the boundaries of basic civility standards, and the board, as it will be constituted, will probably allow that. Category 2, rules that require individual scrutiny to be deemed lawful. These are rules where it's a closer call as to whether the employer's legitimate justification is going to outweigh the impact on Section 7 rights. And then unlawful rules that would clearly prohibit NLRA protected conduct or speech. A couple of examples of that would be a work rule that prohibits employees from talking about their pay, or work rules that prohibit employees from making a negative statement about the employer on social media without any other specifics as to what's forbidden. The previous case that we discussed, the saving grace for that rule was that there were items that were forbidden, including discrimination and defamatory speech, such that the board determined that a reasonable employee would be able to interpret that rule to mean that those types of things were prohibited, but general complaints about pay or work rules would not be. What the thought is, as the board transitions to a Democrat majority, is that when given an opportunity, the board will revert to prior board precedent, and that will result in work rules being deemed unlawful if they do infringe upon Section 7 rights, that there isn't going to be a close examination in those cases. Category 1 rules are likely going to still be allowed, but Category 2 is thought that any examination of the work rule in which there is a more than de minimis infringement on an employee's Section 7 rights is most likely going to be deemed unlawful. So again, I think the key here is for employers to look at their work rules, make sure that they're only as broad as would be allowed, specific where they need to be, and in most instances where there would be the potential infringement on Section 7 rights, to include some level of a disclaimer that would indicate that there is nothing here that's intended to infringe upon Section 7 rights, and perhaps provide an example of what those Section 7 rights might be. But the idea is that you don't want to have rules that are going to so severely limit your employees' abilities to complain about terms and conditions of employment that they just simply feel like they don't have the right. And you certainly don't want to be disciplining an employee for a civil conversation or complaint raised about pay or work rules, attendance policies, things like that. One of the more significant legislative developments that is occurring right now is the Protecting the Right to Organize Act. It has passed the House of Representatives, and it did so on March 9th, 2021. The Senate, if you've been paying attention to the news, things that have been passed by the House of Representatives run into some roadblocks in the Senate, given the narrow, thin majority that Democrats have, and the fact that there are some conservative Democrats in the Senate. It's to be determined what this law might look like if it does achieve passage. One thing to keep in mind is that unions fully support this law, and it is one of the things that is driving union support of this administration. They support it such that the infrastructure package that has been proposed by President Biden may lose union support if the Protecting the Right to Organize Act is not a part of it. And given the fact that that infrastructure bill is struggling to get through the Senate in and of itself, any loss of support from unions might make it almost impossible to get a significant infrastructure package passed. So while you might not necessarily think that an infrastructure package impacts labor and employment law, given the fact that everything is tied together in Congress and politically speaking, just generally, it's very obvious that labor and employment laws have an impact on most issues that come before the Senate, particularly when there is such a push as the PRO Act from unions. One of the key provisions, and as you may recall, in 2015, Wisconsin passed right to work legislation. And right to work legislation, at its most basic premise, is that employers and unions can't come to an agreement that require employees within the bargaining unit to join the union in order to maintain employment. Union membership cannot be a condition of employment. And what that has done in certain contexts, it has led to more and more employees opting out of unions where collective bargaining agreements had previously had union security clauses. Union security simply meaning that employees had to be a member of the union or they could be fired. Well, what right to work does from the union's perspective is it creates what's called a free rider problem, meaning that there are employees in the bargaining unit who simply get the benefit of the union being present and negotiating agreements, and therefore they just simply don't have to pay dues. What the PRO Act would do is would attempt, at least in that respect, to override state right to work laws. There's 27 states that have right to work legislation that has been enacted. I don't believe that any of those states that have enacted right to work legislation have ever gone back the other way. The idea behind right to work is that employees should have a choice whether they want to join a union or not. The PRO Act would create a scenario where contract language in a collective bargaining agreement stating that all employees in a bargaining unit shall contribute fees to a labor organization for the cost of representation, collective bargaining, contract enforcement, and related expenditures as a condition of employment shall be valid and enforceable, notwithstanding any state or territorial law. Whether Congress ultimately has the ability, whether this would be a constitutional provision, is to be determined, and I'm sure that would be litigated. But what this does is it would require employees in a bargaining unit to pay for those services that are provided by the union, even if they don't want to be union members. Another key provision of the PRO Act is that it would prohibit employers from forcing employees to attend meetings, often called captive audience speeches, regarding management views on unionization. If you recall, there was a big union organizing drive down in Alabama at an Amazon facility down there that ultimately failed. And one of the complaints that labor groups had was that Amazon had the ability to require employees to go to these captive audience speeches where the employer could attempt to convince employees to not vote in favor of the union. Now, one thing that the labor groups tend to forget is that during those during those talks, while employers are allowed to try to convince, they're not allowed to promise anything. They're not allowed to guarantee anything, and they're not allowed to tell them anything that's not true. Now, the meetings can be mandatory, and that's one of the things that they balk at. But the fact of the matter is that when it comes to union organizing drives, unions can conduct meetings, and nobody really has an idea, other than those who attend, what gets conveyed to potential bargaining unit members during those meetings. And employers simply take the opportunity during these drives to provide factual information to employees. And in most instances, the idea behind them is in the hope that employees will vote against having a third party, i.e. the union, involved in the relationship between the employer and the employees. Another key provision is that employers would have to report payments that they make for labor law counseling during the election process. So employers would have to identify what they paid for counsel and support during an organizing drive. It would also make it easier for unions to communicate with potential members. Require employers to share employees' personal contact information, including home address, home phone number, personal cell phone number, and personal email address, with union organizers in the weeks before an election. The thought is that even some employees might have a hard time with this provision, in that it would be providing personal information to a third party, not necessarily with the permission of the employee, but simply because the law requires the employer to provide this information to union organizers. Another provision is that employees would be allowed to cast ballots off of property. Currently, those ballots are generally, the pandemic notwithstanding, but generally cast on the employer's property. The idea here is that the unions believe that they would get a fairer vote if there wasn't the potential threat of doing this at the employer's property. Most of these threats in common practice don't really exist. It's not to say that there aren't employers who have run afoul of various electioneering laws and union organizing campaigns, but generally speaking, these type of elections go off without a hitch. There's no electioneering where the ballots are being cast. They're confidential, and they're anonymous votes. So, the idea that casting them off property would somehow serve as a benefit in the face of, I guess, a straw man argument that casting them on property has somehow been detrimental, I don't know how real it is. You might recall that there was relatively recently, a major decision by the United States Supreme Court that confirmed that class action waivers in employment arbitration agreements did not violate the National Labor Relations Act. Well, the PRO Act would reverse that. It would make such agreements unlawful, and this would ultimately allow for more class action litigation. In addition, the law states that employees would be allowed to bring civil lawsuits on their own in federal court, alleging their own unfair labor practice claims. So not necessarily having to take them before the National Labor Relations Board. The thought is that one of the reasons that the act includes this is what I talked about before, is that for a period of time in a Republican administration, the board tilts towards the employers, and then for a period of time it would tilt towards employees. This would allow individual employees to avoid what is perceived as a very political body, and try to bring their claims in federal court. Of course, the issue with that is the judges are in federal court are appointed by elected officials, so you never know which judge you're going to be in front of. But nevertheless, these claims would allow employees to recover back pay, front pay, consequential damages, liquidated damages, punitive damages, and attorney's fees. So it opens up potentially a whole other area of federal litigation that employers would have to deal with. And another key provision is that corporate directors and officers could be held personally liable for violations of the act. And this is something, while the entire act is being fought by Republicans in the House and Senate, this provision specifically is under some significant scrutiny because ordinarily corporate directors and officers are shielded by the corporation from liability for violations of these laws and other employment laws. This act attempts to make them personally liable in certain situations. Additional provisions under the PRO Act are the joint employer rule would permit a finding of joint employer where there is indirect or reserve control standing alone to be sufficient to support a joint employer finding. Right now, as the law stands, indirect or reserve control is not sufficient to create a joint employer finding. This would change that. It would change the board's union election rules and impose new arbitration procedure on employers. The idea here is that it would speed up the election process and to attempt to avoid delays, allow elections to go through and challenges to the bargaining unit makeup and things like that to be done after the fact. If no collective bargaining agreement is successfully negotiated within 90 days of certification of a union, then a contract could be imposed on the parties by what is termed a tripartite arbitration panel established in accordance with such regulations as may be prescribed. So in essence, creating an interest arbitration where the arbitrator's decision would be binding on the parties, then that contract would be binding on the parties for a period of 2 years unless the parties agreed otherwise in writing. It takes really the control of the terms of an agreement out of the parties' hands and puts them in an arbitrator's or a group of arbitrators' hands. Regarding strikes and lockouts, employers would be prohibited from locking out employees and from permanently replacing strikers, two economic weapons that employers currently have. It would allow extremely disruptive intermittent strikes. And this is, as it sounds, sort of like intermittent FMLA, that a strike could start and stop and start again and stop, which, as you can imagine, would be incredibly disruptive to production and to businesses generally. And then it would strip away employer protections against secondary activity, threatening to enmesh neutral third-party contractors with labor disputes arising on a common job site, so that even if a particular bargaining unit is not on strike, it would allow other union workers or bargaining unit members in other entities to engage in a sympathy strike without penalty. Independent contractors would largely become a thing of the past. Right now, independent contractors are determined, whether someone's an independent contractor, determined by an economic realities test, which is a multi-factor test that allows for, on a fairly regular basis, the finding that an individual is an independent contractor. The push is to try to eliminate independent contractors to the extent possible. And it's borrowing the California ABC test, which does not allow employers to classify workers as independent contractors unless the individual is free from all control and direction in connection with the performance of the service, that the service is performed outside the usual course of business of the employer, and that the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. It's a much more stringent test in order to establish independent contractor status. And you can rest assured that anytime the federal government is adopting something that is in place in California, that the likelihood is that it's going to be far more employee friendly than anything that you are used to. Now the question is, will this become law? And President Biden has signaled his full support of it. The House has already passed it. The question is whether it will get through the Senate. Without some significant changes to it, it's unlikely that it would get through the Senate. Filibuster would likely prevent passage of the act in its current form. And as a result, it seems somewhat unlikely as it's presently constituted to get through. But as I indicated before, union support of the infrastructure package, which is a big part of President Biden's agenda, is really tied to the PRO Act. And this will be a real turning point for the Biden administration, I think, as it relates to union support, because there were a lot of promises made during the campaign supportive of unions and those things that the president was going to try to accomplish that would be favorable to unions, this being one of those things. And should this fail, it seems unlikely that his significant support that he receives from unions will be maintained. Another issue that has come up and that was part of the government's most recent COVID relief package that was passed once President Biden took office is the Emergency Pension Plan Relief Act. And you likely know that pension plans, multi-employer pension plans in the United States are in significant jeopardy. Approximately 200 plans are nearing insolvency. There's approximately 1,400 of those plans total. They vary in size. There's 1 million, in the 200 plans that are in jeopardy, there's more than 1 million retirees. And that's retirees. That doesn't include those individuals who are still working for an employer that is making contributions to a pension plan. More than 100 of these plans that are struggling are in what is known as critical and endangered status, meaning that within 20 years, and 20 years is quite a long time, but many of them it will take far less time than that to reach insolvency. One of the biggest that is having incredible struggles is the Central States Pension Plan, which is Teamsters pension plan. And it has been poorly run. It hasn't been funded particularly well, as many are not currently. And it is in significant jeopardy of those employees who are currently receiving contributions on their behalf, and those who are collecting benefits may have their benefits cut off or significantly, some of them already had their benefits significantly reduced. And therefore, the idea was that as part of this COVID relief package, to slide into it some pension relief. The pension relief that they slid in is this Emergency Pension Plan Relief Act, or the Butch-Lewis Act of 2021. The idea behind this is that the plan, the Relief Act, will provide more than $86 billion to fund pensions that are severely underfunded presently, and guarantee pension benefits to those retirees and workers who will retire and collect benefits through 2051. Many people feel that the $86 billion is simply not an accurate figure, that it's going to considerably exceed $86 billion when it's all said and done. And as indicated here in the slide, there is not a cap that's set on the cost. So it's potentially something that could increase over time. This money would be provided by Congress to the Pension Benefit Guaranty Corporation, which is, in its most basic sense, an insurance entity that provides support for multi-employer pension plans. And you can sort of equate it to the FDIC, which insures deposits at banks up to $100,000. The PBGC itself, without this support from the Emergency Pension Plan Relief Act, was set to become insolvent in 2025, no later than 2026, which is just another indication of just how difficult things have been for pensions. This act, while it seems like a significant change, is really just another effort by Congress to support pensions in a series of acts by Congress. ERISA, which we're all probably familiar with, was enacted in 1974, and a significant part of that law was to help support pensions and create some guidelines for pensions. The Multi-Employer Pension Protection Act of 1980 added to the ERISA legislation the Pension Protection Act of 2006, when President George W. Bush was in office, also modified the pension provisions. And now we have this. One of the criticisms of the Pension Plan Relief Act is that it provides money to the PBGC, but then has the PBGC simply dole out lump sums to these funds that are in critical status. And in doing that, it doesn't provide any sort of structural change to how these pensions are run, the money that they currently have. It does require of them to keep the government funds separate, and directs that they be invested in conservative investments such that there's less likelihood of significant losses. But again, it doesn't provide any structural sort of change to how multi-employer pension plans fund their other or invest their other funds. So the concern is that without that sort of structural change, we're just going to see the same thing happen again in the future. One thing that this does is it temporarily delays the requirement that employers identify their funding zone or change their funding zone designation. The funding zones are really color-coded Green means that a pension plan is fully funded, at least from a percentage basis. The idea being that the funds within that pension plan would be able to pay the benefits for those who have retired and those who will retire. Yellow means endangered, and generally means less than 80% funded. Orange, not often used, means seriously endangered, which makes me think of A Few Good Men when the question was danger or grave danger. Is there any other kind? Well, if you're endangered or you're seriously endangered, I'm not sure there's much difference, but for certain, the orange category would mean that a fund is nearing the red category or critical status, which means that it's less than 65% funded. Another non-color coded status is critical and declining, and that would be those plans that I mentioned earlier where insolvency will occur within the next 20 years. One thing to note is that an employer, once it reaches yellow status, it can voluntarily declare itself in red. The idea behind that, and one of the plans that just recently did that, is the Machinists National Pension Fund. They did so in order to create a rehabilitation plan. And the rehabilitation plan is a plan that is designed to do exactly what its title would suggest, is rehabilitate its fund. And one of the things that this legislation does is it extends these rehabilitation plans by 5 years. Ordinarily, a fund's rehabilitation plan would be enforced for 10 years. This allows those plans to be extended to 15. They can be seriously endangered plans, have the ability to create 15-year rehab plans. Accordingly, extending that by 5 would be 20 years. The impact on employers with these plans is that these plans automatically increase the contribution rates for employers to the funds. With the IAM National Pension Fund's rehabilitation plans, or rehabilitation plan, the preferred plan requires, during the life of the rehabilitation plan, a 2.5% compounding increase in the contributions made by the employers to the plan. So you can only imagine the significant increases over the life of a decade-long rehabilitation plan that would be in place. Now, the prospect is there that plan could be extended to 15 years. So 2.5% compounding annually over 15 years is going to make for an incredibly costly contribution. The ultimate problem with these funds, just generally speaking, is that they have more individuals who are collecting benefits or who are eligible to collect benefits than they have employees for whom employers are making contributions. And it's not a sustainable model, because we talked about earlier, the union membership is declining. It continues to decline, and therefore, unless employers who have unionized environments and have pension plans in place make significant hiring increases, or the unions that are affiliated with these pension plans certify a large number of unions in a variety of employment sectors, those numbers just aren't going to change. And what this ultimately leads to is a scenario that employers are attempting to withdraw from these plans. You'll note that I referred to previously that this would create a separate fund within the PBGC to provide financial assistance. For an employer pension, a multi-employer pension plan to be eligible to receive this financial assistance, it needs to meet one of the 4 conditions outlined here. It needs to be in critical and declining status for a plan year beginning 2020 through 2022. Every employer that is a contributor to a multi-employer pension plan is supposed to receive a funding status annually. They usually come out around this time every year or a little bit before. Some funds it varies, but annually employers, contributing employers are to receive these funding status documents. You should pay close attention to it to see just exactly where a pension fund you might be affiliated with is from a funding perspective, because those that are in critical and declining status are likely to receive some benefit from this. And ultimately, the thought would be that the funding that they receive would probably embolden unions to not allow employers to withdraw. One thing that this act did not do is it did not provide any guidance as to how these contributions might affect withdrawal liability. A fully funded pension from which an employer attempts to withdraw leads to almost none, but certainly very little withdrawal liability, depending on the ultimate funding status of the pension plan, assuming that this assistance would be sufficient such that it would fully fund, and the idea is that it's going to fully fund these pension plans through 2051. The idea would be that there wouldn't be withdrawal liability. Now, it's hard to say how this is going to ultimately play out, but my sense is that they are not going to go the route of eliminating withdrawal liability for these funds that receive these benefits. The PBGC makes its rules. It should be doing so shortly. It was 120 days from when this was enacted. Those 120 days come up within the next, I believe, 45 days. So we'll see how this plays out. I think the thought is that withdrawal liability may still apply based upon the funds that have been collected by, by the pension plan from contributions, and that the funding that is received from Congress through the PBGC would not impact the withdrawal liability, or would only impact it on a percentage basis. The funding that I've referred to that these funds will receive will be equal to the amount necessary for the plan to pay for all accrued benefits owed to retirees without reduction from the date of payment of the special financial assistance until the last day of the plan year ending 2051. So the idea would be that for the next 30 years, this funding assistance is going to guarantee pension benefits for all of those retirees who are either now retired and collecting, those who are currently eligible but are not collecting for whatever reason, because perhaps they switched employers and are no longer receiving contributions on their behalf, but are still eligible to receive pension benefits at some point. And then those employees who are currently part of a pension plan and a collective bargaining agreement that provides for contributions under it and for whom contributions are being made. So the number of individuals that this financial assistance is intended to support is incredible. And the idea that this would be fully funding all of those retirement benefits through 2051 would lead one to believe that these plans are going to be fully funded. The question becomes, what happens to the pension plans funds from now until 2051? I'm sure some of us will be here to see how that plays out. My guess is that if it has worked like these pension plan acts have over the course of time, that we'll be looking for more funding from the government when we get to that point. As I indicated, the PBGC should be issuing its guidance relatively soon. They could issue regulations that restrict plans that receive assistance from reducing future employer contributions. The idea there is that in each collective bargaining agreement that's negotiated, the contributions are similarly negotiated. Most often, the union will, as part of the negotiation, seek additional contributions from the employer to the pensions of the current employees. The PBGC could likely issue regulations that say that employers and unions are not allowed to reduce future employer contributions, with the thought being that that would be a part of the negotiation, simply because if the government is going to be bailing out the fund, it would seem to me that the employer should not have to be on the hook for such sizable contributions. But the concern from the PBGC's perspective is likely that it doesn't want these contributions to cease, because all that would mean is that the government's just simply going to have to contribute more money to the funds to make up for those dollars that aren't being contributed by employers. In addition, one thing that if you've been involved in any collective bargaining, if an attempt to withdraw from a fund is a very challenging thing. It's scary for union members, but in addition to, or beside that, is attempting to reduce your contribution is also a very challenging one. Pension contributions, much like health insurance premiums and taxes, usually go up. But it's really infrequent that they ever come down. Some would argue that they never come down. Here we're talking about the same thing. It's unlikely that a union is going to be all that interested in reducing pension contributions to its retirement plan, but the idea is that the PBGC could severely limit that. The practical impact here is that withdrawing from pension funds that receive considerable assistance here could be really difficult to do. Like I said before, unions will likely be emboldened to stay in, knowing that they will, that their retirements are going to be, in essence, guaranteed within the pension plan, and so it's probably a strike issue going forward, particularly for those funds that will be receiving considerable assistance. The other thing that is practically going to impact employers is that the costs of being in the pension fund may increase, because funding rates, particularly the PBGC's flat rate premium for all plans, is likely going to increase within the next 10 years. And so there are going to be costs associated with this that are probably going to be borne by employers. And unfortunately, if the guidance that we think is going to be issued by the PBGC comes to fruition, there's going to be very little opportunity for employers to reduce what they contribute. So while this is probably needed from the perspective of those employees who believe that they were promised a pension and were promised a pension and they were promised a retirement, there does not appear to be a lot of, if any, relief on the horizon for employers as it relates to this act and the changes that are going to be made to the multi-employer pension program. I think we have a few minutes left for questions. I didn't note that there were any as we were going along. If there are none, I thank you very much for attending. And we need to announce our big winner. And the winner is Debbie Dean, or Dane. It's spelled D-A-E-H-N. So congratulations. You can contact Mary Beth or info@Lindner&Marsack, or so that you can claim your prize. Again, thank you very much for attending. I hope you have a great rest of your Wednesday.